that relates to the cost order de bonis proprius at the Supreme Court. It was Judge Olin. It's Aztec Granite Pty Limited versus Andrew Stanley Green and another, or two others. It's a Supreme Court case number 4 of 2005. I just found it on Safely. And Aztec, A-Z-T-E-C, Aztec Granite Pty Limited versus Andrew Stanley Green and two others. And it is Supreme Court of Appeal case 4 of 2005. So you'll find it on Safely, and you'll see right at the end the judge, what happened in that case was that the respondent, who sort of striking out of the appeal, had failed to file its power of attorney together with its heads of argument, and as a result it said the striking out should be without a cost order. And the court then agreed and said, but in conclusion, I must warn that this court will in future have to consider to issue orders for costs to be paid de bonis proprius by legal practitioners because of the vast increase in recent years of appeals that had to be postponed or even struck off the roll by this court because of negligent acts or omissions by legal practitioners. So that's the matter that I was referring to earlier. All right, so let's just pick up where we left off. We are at judicial case management, so we're just navigating sort of bird's eye view from what the process is. So you have case planning, which is before close of pleadings, and ADR, case management, and then you proceed to pretrial conference. Case planning conference, it's Rule 23. A case plan, the question is, must it be submitted? So must the parties submit a case plan? Who thinks the parties must submit a case plan? One. Who thinks they don't need to? No one. Okay. Sorry? So there's 2 that think that they do need to file. 3, 4. 4 who thinks that they do need to file a case plan. Okay. The reality is that the parties don't need to file a case plan, because if they don't, then default time, the judge will set the timelines. The judge will issue timelines, normal. It's a risk that parties take because each case is unique, and a case may require, for instance, summary judgment, irregular proceedings, whatever. So if you don't file a case plan, the judge will just say, file your plea, file your counterclaim, this is how you're going to exchange pleadings, and we're proceeding. So it's prudent that the parties deliver a case plan where they deal with what is set out in Rule 23. That's whether a party is going to apply for a summary judgment, and if so, when exchange of pleadings will happen. That would be the application for summary judgment, and then the affidavit resisting summary judgment, and then whether heads of argument will be filed or not, and a set down of the matter. You will note that the rule also makes provision for when these types of interlocutory matters must be heard, how soon after they are brought, etc., etc. You can have a look at that in the rules. The other thing that you may need to deal with is exceptions and striking out. We'll deal with exceptions and striking out tomorrow. If you want to bring an exception or striking out, then you need to set out the basis of that. You can't just say, yes, I want to accept. You need to say in broad terms. You don't need to file with the precision that you would in the actual exception, but you need to say, I'm going to move for an exception on the basis that either it's vague and embarrassing or doesn't disclose a cause of action, and that is because of this, that, and the other in broad terms. Same with striking out. Alternatively, you can say, I'm going to want to rely on Rule 61, irregular proceedings, and then the time limit for that, etc., etc. Alternatively, the dates for exchange of pleadings, discovery affidavits, and any other issue appropriate. Now remember that some parties deal with witness statements here already. It's fine because you can under any other issue appropriate. if you want to rely on summary, you want to move for summary judgment or raise an exception or move for striking out or raise an irregular proceeding, then further pleadings will be stayed until such time as that particular interlocutory issue is sorted out. So does that make sense? So you can't move forward with pleadings until the preliminary issues have been sorted. You also can't make discovery and all of the rest. Some summary judgments and exceptions, well, summary judgment may easily dispose of the matter, exceptions same, irregular proceedings also. Now please compare what is required in terms of irregular proceedings with Rule 61, because Rule 61, make a note for yourself, we'll deal with that tomorrow when we deal with irregular proceedings, but Rule 61 says that within 10 days after becoming aware of the irregularity and without taking a further step in the proceedings, you need to file your notice for irregular proceedings. However, Rule 23 says you must set out in your case plan when you are going to do that. Well, case planning would be, in most instances, would be long after the irregularity has arisen, because you'll have your, I suppose we're done with ADR, so I can. So, you'll have your summons, and you'll have your notice of intention to defend. Now remember, this is not taking a further step in the proceedings if you file this, so you won't be, you won't find yourself without a remedy in terms of Rule 61. But now the summons, for instance, refers to a written agreement. Let's say it's a written agreement. And the written agreement is not attached, which means that it's not in compliance with which rule? (45). Okay, so it's irregular, because you can't rely on a written agreement and not attach it to the particulars of claim. So it's an irregular proceeding. So you're prejudiced because you substantively and procedurally, a party, a litigant, a defendant is entitled to have sight of this agreement because it should be attached to the particulars of claim. It's not, so there's prejudice. We'll deal with irregular proceedings. But essentially, now you want to raise this. You want to rely on Rule 61 as this is an irregular proceeding. But case plan takes place here. This is summons is served, say, on 3 October. You file your notice of intention to defend by 15 October. And then the case plan, it's docket allocated, etc., and case planning then takes place here, which is, let's say, 3 November. But you would have noticed, now let's make this 23 November. More realistic. So you would have noticed this irregularity the moment your lawyer told you it's not in. So by the time you filed your notice of intention to defend, you reasonably should have been aware of this. So now 10 days have passed and you're still not at case planning, but you want to use Rule 61. It's a problem. It's a dilemma I've been faced with previously, and there's no well, in that particular instance, the instructing practitioner and I differed on what a party should do. What do you think a party should do? Should you then wait for case planning and say, well, I am now entitled to rely on Rule 61 because I had to wait for case planning? Is case planning taking a further step in the proceeding? If you take part in case planning, do you simply file your notice in terms of Rule 61? What about Rule 32, 9 and 10? What about the 10-day period in terms of Rule 61? It's not there for nothing. So these are all important considerations. So you see how the rules sometimes cooperate and don't cooperate with one another. And here a party may be faced with quite a dilemma, because case plan, and are you even allowed to file a pleading before case planning? So are you allowed, is the defendant allowed, case planning is set for 23 November, is the defendant allowed to file its plea by 23 October? Why not? If you're ready to file your plea, why not? And say the case plan, I've already filed. So the case planning conference doesn't give the party the right to file pleadings. You have that right. The case planning conference is merely to regulate how pleadings will be filed. But I think in the case of an irregular proceeding, which is something you need to deal with, if the 10-day period is already prescribed, the 10-day period in terms of Rule 61, you are going to have trouble here, because the other party will say, well, look, you had 10 days, you became aware there, you didn't use the 10 days. And then to say, well, I waited for case planning, it's probably not going to take you much further. Moreover, another issue is the fact that taking part in case planning might actually be seen as taking a further step in the proceedings. Now, if you take a further step in the proceedings, you forgo the right to rely on an irregular proceeding. So these are difficult questions. It hasn't been tested yet. It'll be interesting to see what the courts say about this. But you see how, for instance, in this scenario, there is a difficulty between case planning and Rule 61. So I know I'm not making your life any easier, but that is the situation that we are faced with. All right. Effect of not setting out a procedural step in the case plan. Now that's fairly simple. For instance, where you don't say that you want to apply for summary judgment or for an exception or an irregular proceeding, I think it's fairly simple that you lose the right. You have said, I'm not going to, you can't come back later and say, no, sorry, now I want to raise an exception. You have chosen to proceed in a certain fashion, and you will be, unless there are exceptional circumstances, you will be bound as a litigant to what you have decided. However, the situation changes slightly when, for instance, the parties have agreed, and we spoke about this yesterday. The parties now agreed in the case plan. Particulars of claim has been filed. And what the parties usually do in their case plan is they say, so one, the plea and counterclaim will be filed on a particular date. And then they say, two, the replication and plea to the counterclaim will be filed on a particular date. And then they say, three, the replication to plea to counterclaim will be filed on a particular date. Because those are normally what parties expect the pleadings to be. But none of us have crystal balls. None of us can foresee what's going to happen in future. None of us know what issues are going to be raised in these pleadings. So now it happens that someone raises something in this replication that I feel I need to file a rejoinder for. Now, what now? Did I lose the right to file a rejoinder because I didn't have the foresight in the case plan to anticipate that a rejoinder will be filed here? Well, it says dates for exchange of pleadings. We've only agreed up to here. So strictly speaking, the parties should set dates for filing further pleadings such as rejoinder and surrejoinder, but where are you going to stop? So it's quite reasonable, I would say, to expect that usually matters stop at replication. Well, not there at this stage. Usually matters stop there. They don't usually proceed to rejoinder and sur-rejoinder, but the right is there. So what would a party do? Or parties say, look, I mean, I've received your replication. I think I want to file a rejoinder. I think we should call a status hearing so that I can ask the judge for a date to file the rejoinder. So it will depend on the complexity of the matter, the parties, the circumstances, etc. The parties make a proposal, and the judge then has the final say. So what would essentially happen is in a run-of-the-mill type of action, the court would probably say, okay, within 15 days you can file your plea, and then you file your replication within 15 days. 15 days is generally, I think the 15 days have stuck from the previous dispensation where it was 15 days and 10 days. So 15 days is somehow the norm in the run-of-the-mill type of litigation. I've recently, before a judge like Judge Geyer, who is very strict on short time periods, in circumstances where the parties have addressed him and said, look, this is a matter of extreme complexity, and we would have to consult witnesses in South Africa in order to plead and look through a number of documents, etc., etc. So please give us 2 months to file our plea. And that's been done. So it'll depend very much on the complexity of the matter. And you must be mindful of the fact that the overriding consideration is obviously to save time and costs and whatever, but one must ask yourself, in a complex matter such as that, what are you doing by forcing a party to then file its plea within 15 days? You're actually depriving that party of their right to a fair trial. They've been dragged to court in this complex matter, and they are now being deprived of their right to a fair trial. At what prejudice? At what cost? Just because the overriding principle says make it quick. Make it quick within the circumstances. So you've got to have a feel for justice. The judge must make a decision that will, in the end, advance the administration of justice, but also in that process, and it's inherent in the administration of justice, that parties are given a fair chance. So it will depend on the circumstances. The parties make they agree between themselves and make a recommendation, and the judge then issues an actual court order, which sets out the dates.
The timeline.
Yes, absolutely. It's called a case plan order. 12 months probably not, but 2 months, 3 months, yes. I've recently had to file an opposing affidavit in a matter where the matter evolves, so it's not black or white. Any matters, like with any trial, it evolves. So the parties come to court at case planning stage. They come to court and say, this is the claim, this is the complexity, we need this much time to finalize the pleadings. It's going to take us 3, 4, 5, 6, 7 months. That's how that works. Then you move over to case management. Then comes the pre-trial proceedings in case management and in pre-trial, which you then deal with, which may in itself take time or take less time or take more time. So you can't really always predict these things right at the start, and you don't need to. You're busy with case planning, so all you need to do now and concern yourself with now is what is required in the case plan, and make sure that that is done to still protect the parties' constitutional rights to a fair trial, but at the same time you are balancing the overriding principle of the ethos of the civil justice system in Namibia, which we've dealt with earlier. So that's all you're dealing with at that point in time. And then when that's done, you move over to the case management conference where you deal with other issues, and there you need to concern yourself there. So you need to try and divorce the whole trial from the case planning stage where you are at now, because that's what you'll be dealing with now. And that's what you need to concern yourself with at the moment. So you can't say here, but okay, I'm not going to give you 2 months to plead because I want this whole matter finalized in 8 months. You can't do that. So what happens is it will be set down automatically for case planning. But of course, the court won't know, and e-justice won't know that someone wants to apply for summary judgment. So it's set down for case planning, and then in your case plan you say, I'm going to apply for summary judgment. You don't deal with the rest. Then that case planning conference it's called in court, or a judge issues an order in chambers if there's no issues. I mean, you can also do that, and parties don't have to physically appear. But a court order will follow that case plan, and then the actual case planning conference will be postponed to a later date. So that's how it works in practice.
So it's like a provisional
No, there will be a case planning conference. Look, I mean, the practice is that orders can be issued out of chambers without the parties appearing, where, for instance, they say, I'm going to apply for summary judgment. Within 10 days, I'll file. Within 15 days, I'll file. Everything is in order. The judge says, okay. He looks at the case planning case plan. He says, I'm in agreement with this. I'm going to issue the order in chambers. You don't need to come and see me in court. But it's as if the matter was called in court, and it's an order proper, just like as if the matter was in court. And then the case plan in that order would say, and this case planning conference is then postponed to this date so that the court can first deal with this. So it just really postpones the matter, but it is called in court, and there is this ongoing case planning conference. So does that make sense? I know it can be confusing because reading it in the rules is one thing, but seeing it in practice makes it much easier. Okay, you go read the recent Supreme Court judgment of De Savino, and then you tell me, I'll give you the citation before the end of the day, then you tell me whether you think that order is appealable. That is case planning. So parties better be well prepared in their case plan and set out whatever they want to do. Any other questions on case planning? Okay, so then the case plan happens. It's filed. Let's say for the moment no interlocutory motions arise. We'll deal with interlocutory motions tomorrow for the greater part of the day. But let's say no interlocutory motions arise. So pleadings are exchanged. Then what the court can do is then to say, all right, parties, the last pleading would be filed on 4 November. Then pleading should be closed. Okay? So I'm going to set the matter down either for a status hearing or I'm going to postpone it to a case management conference. Because that's the next step, case management conference. So, why would a judge set a matter down for a status hearing? That's why a judge would set a matter down for a status hearing, particularly a matter where the parties have said, well, I'll file my plea in 2 months' time, but I foresee trouble, or the parties are waiting for someone to do something, or whatever the reason may be, and the judge is not certain that the matter will actually on this date be ready to proceed to case management, then it's set down for a status hearing. Remember that the parties may also request a status hearing. So, for instance, let's say the case management the case plan has been issued and the matter has been set down for case management on a particular date in the future, which is the normal course. Then, of course, something happens. Life always happens. So something happens in between, which means that, let's say, the replication can't be filed because the witness or the client who must now give instructions relating to the replication had a heart attack and is in South Africa in hospital incapacitated in the moment, which means that you can't file the replication. So strictly speaking, if you don't do it, you lose the right. You're not in contempt, as I've said earlier, because if you don't file it, then you just can't use it later. The issue is just that you may still want to file the replication, but now you can't because your client is incapacitated. Then the party who is in that position calls a status hearing. Asks the judge through the correct channels for a status hearing, sets the matter down in the next case management role, explains the situation and says, can we please agree on a new date for this replication? And when that's done, more often than not, the court will again set it down for a status hearing because hopefully the client will be better by the time they've now agreed for the replication. But again, there can be complications. So I'm just trying to explain how this would work in practice so that you have an understanding. So all other things being equal and the case plan having run its course and the pleadings having been filed and there are no issues, the matter will proceed to case management, which is the next step in the procedure. The case management, okay, this is the case plan, we're still there. All right, then we move to what is called the case management conference, and that is in terms of Rule 25. So if we can just turn to page 20, Rule 25. Now, perhaps I just want to see in this file of yours, you'll find under case management and court orders, which is one of the sections in the indexing and pleadings, you'll find on page 42, that's what is sent out. It's a case planning conference notice. It's on page 42, and it's the first page under case management and court orders. And then the judge calls upon the parties to attend a case planning conference on a certain date before a certain judge. And the parties or the legal practitioners are directed to submit a joint case plan in terms of Rule 23(2) and 3, at least 3 days before the case planning conference, and take further notice that whether a case plan has been submitted or not, an order in terms of this rule may be made by the managing judge as the managing judge considers just, and on failure to submit a joint case plan, the parties will be barred from applying for summary judgment or filing a notice to accept of, or strike out of strike, but notice of exception or strike out it should read. But that is what a case planning conference notice looks like. So once an action is defended, a notice like this would be sent to the parties. Then the parties filed, in this instance, they did file a joint case plan, and it looks like you would find on page 39 to 41. It says, these are the parties on behalf of whom certain legal practitioners appear. Whether the plaintiff intends to apply for summary judgment, it's no exception or strike out, no notice of irregular proceeding, and then they say plea and counterclaim was already filed on 4 April, you see. So in this instance, it was already filed. Plaintiff filed plea to defendant's counterclaim on 15 April. No replication will be filed to plaintiff's plea to defendant's counterclaim. They agree that discovery will be made at a certain date, and a date for case management can be set. So fairly straightforward, pleadings almost closed when this matter was called. Now it's a motor vehicle accident, so there's an initial mediation referral order. The court says this matter is referred to court-connected mediation. The parties must approach the Alternative Dispute Resolution Office on or before 25 June for purposes of reserving a court-connected mediation session, and the matter is postponed to 16 July 2014 for purposes of the mediation referral proceedings and for both counsel to provide the identity of the mediator and proof of reservation of the date of the mediator. So that's the order that's then made. Matter is referred to ADR. Then on page 44, you'll see on that date, that's on the 16th of July, an order is then issued in terms whereof the matter is referred to mediation, court-connected mediation. And then here, the matter on the last paragraph, paragraph 10 or 11 on page 45, you'll see the matter is postponed to one October 2014 at 8:30 for a status hearing. So here it's sent to mediation. It might settle, it might not settle. So the court will first want to establish the status of the matter before it then proceeds to refer it to case management. Now, as you can glean from the contents of this file, it actually was unsuccessful, so a mediation report would be filed, as it was in this case, and the mediation report simply says, you'll find that page 46 onwards, that the mediation was held, the matter could not be settled. End of story. So the matter comes back on 1 October for the status hearing, and then the court says, okay, on 1 October I postpone it to 5 November for a case management conference, and the parties must file their case management report 4 days before the case management conference. So please bear in mind, although filing of a case plan is optional, for case management conference and for pre-trial, it is compulsory. Either your case management report or your draft pre-trial order. That's what they are termed. So you can't choose whether you want to file these. You can choose whether you want to file a case plan. So you have to attend the case planning conference, but you can choose whether you want to file a case plan. Okay. So then the matter is, the parties are sent back and they now have to meet and do certain things for purposes of the case management conference. So then we refer to Rule 25. So the case management conference is to deal with all these little procedural steps that need to be completed before we can now sit down and say, all right, we've got everything here, let's see what we're working with. So we've now got everything from pleadings and past pleadings to pre-trial. We've got everything on the table, let's now look at what we're working with. So that's where pre-trial comes in. So here we're just working to get everything on the table still. We just want to make sure that we get everything ready so that we can assess what we're working with. If you look at Rule 25, it prescribes a number of issues that need to be dealt with. First is the joinder of parties. So it might be, we've dealt with joinder, it might be that you realize that you want to join parties because certain pleas of non-joinder has been raised, or issues have come about, or there's a party who wants to intervene, or a third-party procedure, etc., etc., then you may want to do that, and you may want to get a direction from the court under joinder of parties. Filing of further pleadings and consolidation. So it may be that the case plan is now complete and it's been set down for judicial case management, but now you say, oh, wait a minute, I still want to file my rejoinder or my sur-rejoinder. You can deal with that under there. Consolidation of matters, as we've spoken yesterday, 2 separate actions, or 3 or 5 or 10 separate actions that are thrown into one pot and become one matter. Interlocutory motions, so this may deal with issues relating to discovery under the case plan or any other interlocutory motion that crops up at that stage. Now, when I deal with interlocutory motions under the judicial case management, let's just go back for the moment to a case plan. And let's say that in terms of the case plan, you have said, no, I don't want to file an exception. Now remember, and if we go back to that slide, remember when you do a case plan, you need to deal with summary judgment, exceptions, and striking out irregular proceedings. Now, when I talk about exceptions and striking out or irregular proceedings, so it's number 2 and number 3. Remember, at the time that you do the case plan, what pleading has been filed? Only the summons. So you have only the summons. So 1 or 2 is something that the plaintiff would say, 2 and 3 is something that the defendant would say. I've looked at the summons and I don't want to raise an exception, I don't want to apply for striking out, and I'm not going to rely on irregular proceedings. That's what the defendant says, and the defendant says that in relation to the summons that has been filed. But now comes a plea after case plan. And let's say the plea is a bare denial, or the plea hasn't been signed, or the plea relies on a defense which is not sustainable in law. What would the plaintiff want to do? The plaintiff would want to either rely on exceptions or striking out or irregular proceedings, because the plaintiff is entitled to rely on those. But it hasn't been dealt with in the case plan because you didn't have the plea at the time of the case plan. So what do you do now? You would probably file your exception or your irregular proceeding or application for striking out on the date that was set down for the filing of a replication to the plea. Alternatively, you would seek a status hearing. Explain to the judge what has happened, that you want to raise an exception to the plea. The same applies to a counterclaim. If a counterclaim is raised, the plaintiff might want to raise number 2 and 3 in respect of the counterclaim. And again, that wasn't dealt with in the case plan because it wasn't foreseen. So what the case plan should then ideally say, I suppose, is you would, once the plea is filed, you will file a replication or an exception or a striking out or a irregular proceeding. You see. But now you can't say whether you're going to be filing an exception or an irregular proceeding, because the rule says if you are going to rely on these, you need to state that separately. It's not an exchange of pleadings, and you need to set out the grounds for the exception. You see. So, which I think I'm confusing all of you, but you'll have to go back to the judge to say, well, subsequent to the case plan and having now said that the defendant doesn't want to rely on 2 or 3, I as the plaintiff want to, because I've read the plea or I've read the counterclaim and I feel that I want to rely on one of these, and this is the ground why I want to, and so please can you set new dates. Because you don't lose that right simply because you didn't have the power of foresight into a crystal ball to foresee that the plaintiff or the defendant was going to raise an excipiable plea or counterclaim or an irregular proceeding. Well, I mean, that's what a defendant would lose the right in terms of the summons, absolutely.
I'm talking now as the plaintiff in terms of the plea.
No, you don't, because you can't foresee that an irregular plea or an excipiable plea will be filed. So that will only arise once the plea has been filed. And then, of course, you would be entitled. You can't be deprived of that right. The case planning stage may be that the actual case plan conference takes place here, but you'll have exchange of pleadings here and here and here and here, and then only comes case management. So as long as it's in this stage, which we call the case planning stage, because case management only kicks in here once this is final. So this whole stage is called the case planning stage, because the case plan sets out here what must be done, and then it's done, final, here comes case management. And you'll see, as I said, in Rule 25 also makes provision for the filing of further pleadings, because it may be that at the end of case planning, which usually ends at replication stage, you may want to file a rejoinder. You would be entitled to raise that in the case management conference. But then, strictly speaking, pleadings have not closed. I think what I should say at this point in time is that be careful not to have an overly formalistic approach to case management. That I don't think, I wasn't the one who thought up the case management process, so I'm just speaking from my own experience in courts, but I don't think that there's an overly formalistic approach. So don't break your back trying to fit everything into a slot or into an area or into a category. At the end of the day, the court wants a process in which it manages the process, and it allows the parties to ventilate the issues properly, and it does so in a speedy and cost-effective fashion. So don't break your back with trying to fit it into where it doesn't fit, because that's when you start trying to shove a square down a round hole. It doesn't sit well. So here, in those instances I've explained to you, it feels that, well, I mean, I'm going to have to go back to case planning. I'm going to redo the case plan because now I, as plaintiff, want to raise an exception, for instance, to a plea or to a counterclaim, and then I'm entitled to do that. But if, for instance, I want to file a rejoinder and case planning is done and the matter is set down for case management, then it's catered for in Rule 25 throughout. Throughout, even during a partly heard trial, status hearings can be called. I've attended status hearings in partly heard matters that's been postponed to a future date. The court wants to establish whether the parties are still ready or something has arisen or whatever. So status hearings can even be called in partly heard matters. So at any stage of the proceedings, even after judgment has been reserved, a status hearing can be called. It won't be a summary judgment because that's done and dusted once the plaintiff doesn't want to make use of it. It doesn't arise later. And summary judgment is one of those things that you lose if you choose to go by way of counterclaim instead of bringing a separate action. Okay. Now, absolutely right. A party would be entitled to reserve that right in the case plan. But now remember, the case plan says if you want to rely on an exception, or the Rule 23, says if you want to rely on an exception, you must set out the grounds. Now, what would you say there? I don't know. I'm hoping there will be grounds for an exception, but I can't say. So you see the dilemma. As we're strictly speaking, not in compliance with the rules. So you could reserve the right and say that the case plan may need to be revisited if that happens, so that you can file the grounds, or the court says, well, you don't need to come back and tell me, you can just file your notice. So of course you can deal with that. But if a party files, the case plan is drawn on the understanding that the pleadings that will follow will be rule-compliant pleadings that are not excipiable. So if that doesn't happen and the plea is filed that's irregular or that is subject to exception or striking out, that doesn't mean that a party who hasn't raised that in the case plan won't be entitled to rely on it. Most certainly the court. Because remember, exceptions weed out unmeritorious claims or defenses. Striking out is an important mechanism. The court shouldn't allow irregular proceedings to continue. So you won't lose that right. And you can't really, you can reserve the right, but what is this right? You don't know if you have the right. You know, reserve the right to. So the right is, I think, automatically reserved. There's nothing wrong with doing that. But as I said, if you want to rely on those, you need to set out the grounds. And you don't know the grounds because you haven't seen the plea. And it would obviously be of assistance to the plaintiff if the plea is filed prior to the case planning conference. But I can assure you very few defendants want to be of assistance to the plaintiff. So it doesn't happen very often. In fact, parties are always more than happy, defendants are always more than happy to take the time it takes until the case planning conference to file their plea until the date after that's set in the case plan. So I can assure you it happens more often than not that the plea is not filed prior to the case planning conference. So yes, you can reserve that right for yourself, but it'll probably not be a rule-compliant reservation of rights because you need to set out the grounds upon which you will be applying for those. I don't think it's fair to call it perhaps an injustice. It probably is more of an anomaly in the rules, simply because you would only know whether you need to rely on that once the further pleadings are filed. But you would be entitled to do that. A court will not deprive you of that right. So you just need to take the right action. Either file that within the period allowed for the next pleading to be filed, or call an urgent status hearing and say to the judge, this is what has happened, I'm going to have to accept, can you set new dates, please? Okay. So you won't be deprived, it's just that the rule, it's sometimes in practice it's difficult. Good, I'm glad. All right, I'm just going to try and finish at least case management and then, okay, just this slide. for the day, and then we'll continue with case management tomorrow. Just finish off pre-trial, and then I'll start with interlocutory matters. So, all right. So, joinder of parties, filing of further pleadings and consolidation, interlocutory motions, admissions of facts or evidence on consent, discovery, expert testimony and witness summaries, narrowing the fields in respect of witnesses, any other issues and proposed dates, settlement talks, etc. So you can have a look at Rule 25. It sets out all the aspects that need to be dealt with in a case management report. And you will find an example of a case management report. It's not a very complex document, and you'll find an example on page 49 of the bundle that you have. So you'll see in this case, the parties have said there's no need to join any parties, no consolidation, no, the parties have closed, or the pleadings have closed, and they reserve the right to request trial particulars at the trial conference. Then the dates of witness statements that will be exchanged on or before 28 November. Expert summaries by 28 November and defendants on 10 December. No interlocutory motions at this stage. Further discovery, a plaintiff has discovered and the defendant will discover on 20 November. Dates for filing expert reports is already dealt with. Narrowing the field of dispute between expert witnesses. So once the expert witnesses have been filed, the court would sometimes give a direction that the expert witnesses need to meet to see on which aspects they can agree, on what aspects they don't agree, so that the field is narrowed. Then objection on a point of law, if applicable, is not foreseen by the parties. Giving orders or directions for a separate hearing in respect of any relevant issue. It's not anticipated by the parties. Settlement issues, not foreseen by the parties. Mediation has failed. Securing a statement of a special case or law or facts is not foreseen. Date of any additional case management conference. If considered necessary, the parties say no, please set it down for pre-trial. So that would usually happen. An additional case management conference would usually be required where the case management report that's filed and made in order contains certain things that need to be finalized before the matter can proceed to pre-trial. Then the parties may say, there's this preliminary issue, let's deal with it. Once it's done, we'll have a further case management, then we'll deal with the rest, and then the matter can proceed to pre-trial. A matter shouldn't proceed to pre-trial conference unless the case management conference has been finalized. Okay. Dispensing with evidence in chief by substituting it with an affidavit. No witnesses will give oral evidence and will file witness statements. Other issues, it will be considered at pre-trial stage, and that is the full extent of the case management report filed, signed by both parties, filed at court, and then on the court on 5 November makes an order that the matter is postponed to 4 February for a pre-trial conference, and then the case management report by the parties dated 30 October is made an order of court. So that's what happens. That's the process that follows, and that's how it becomes an order of court. So then I accept that you're all experts in case management, and I think we can start with a short exam on case management. No, I'm joking. I'm just looking for that De Savinu. It's Antonio De Savinu versus Nedbank Namibia Supreme Court of Namibia case SA 82 of 2014, and it was delivered on 7 August 2017, and it deals with a party's right to appeal an interlocutory motion. So have a look at that. Case number 82 of 2014, De Savinu versus Nedbank Namibia Limited. It's Shivute, Mahinga and Smuts. It was delivered on 7 August 2017. So regarding whether you can appeal an order, have a look at that and then you can tell me what you think. Okay, so I'm going to be done for the day. I think it's a lot of information. We'll continue again tomorrow morning. Any other questions you want to ask me before we leave? Okay, we'll just recap case management tomorrow. Make sure we're on the same page, but for the rest, I think that's where we're at. All right, thank you. See you tomorrow.